The United States Supreme Court has given us some good news involving the Second Amendment, and it's not from an obvious source. Specifically, the United States Supreme Court just decided a case called Tyler versus Hennepin County, which deals with another aspect of the Bill of Rights, the Fifth Amendment's takings clause. But there's a lot of good stuff in here for you Second Amendment advocates out there, especially you lawyers. Time to get geeky when it comes to Tyler versus Hennepin and how the Fifth Amendment actually can help our Second Amendment right to keep and bear arms. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling new book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. And if you're not following us on Twitter, check us out on @4boxesdiner. We're trying to convey even more information out there on Twitter than I can do so on these YouTube videos. All right, folks. It's my job here at the Four Boxes Diner to connect dots that are not obvious to most, and that is what I'm here to do today. Specifically, a very, very powerful and favorable decision for the Bill of Rights by the United States Supreme Court just came down in Tyler versus Hennepin County. Now, you may have read a little bit about this case. It deals with the Fifth Amendment's takings clause, which really is about protecting private property from government theft. Specifically, the takings clause says that the government cannot take your private property without just compensation. Usually the way this is supposed to work is if you have a piece of property, they want to build a public airport on your property, they have the authority under the law to take that property from you, but they must pay you just compensation to do so. That's in the Fifth Amendment. It's been incorporated against the states by the 14th Amendment in 1868. So that is the law. So why is the Fifth Amendment's takings clause and the interpretation of it in Tyler versus Hennepin by the U.S. Supreme Court helpful to our Second Amendment rights? Well, the answer is it's super helpful in several super geeky ways, but it's going to make you happy when you sit through this. The first is, of course, the current Supreme Court is interpreting all aspects of the Bill of Rights consistent with the Second Amendment. They're trying to bring it into the notion that text and history is what's key and not interest balancing test or tiers of scrutiny, because as you know, when you deal with interest balancing test or tiers of scrutiny, and of course, tiers of scrutiny works this way, that there's acknowledged violation of a constitutional right, but the government comes in and says, yeah, we know we're violating the person's First Amendment rights, but it's so important that we do so that it's not a violation of the First Amendment because we get to balance the interest of the government to violating somebody's rights against the value of that right. And the Supreme Court in the Second Amendment context has repeatedly said, going back to Heller, that you can't use interest balancing test or interest balancing test at all, or tiers of scrutiny at all. It's not allowed, and that's good news. And that is, again, what the Supreme Court just did here in the context of Tyler. They used history, text and history, to interpret the Fifth Amendment's takings clause consistent with the way they are now interpreting the Second Amendment's right to keep and bear arms. So that's good news. By the way, just as a reminder of what this Tyler case was about, because it really, to me, is dirty pool from my point of view as to what the government did here. Specifically, you had a 94-year-old woman, Miss Tyler, who owed taxes and interest and penalties, and you're not going to believe this, but she had a tax bill, according to the opinion here, which I'll put a link to down below, of $2,300. You hear what I just said? She had a unpaid tax of $2,300. However, there was $13,000 in interest and penalties on top of that $2,300. So $2,300 in unpaid taxes, $13,000 in interest and penalties. And here's the kicker. What happened was this $15,000 tax bill was satisfied by Miss Tyler, effectively, who was in a nursing home, by the way, because the state came in, the county came in and grabbed her home that was worth $40,000 and they sold it in a tax sale. So what happened was the $40,000 came in and the government took $40,000 and applied it to the $15,000 tax bill with interest and penalties and paid that off. But then the government decided to keep the remainder of the money, meaning the $25,000 that should go to Ms. Tyler as private property. They kept it because they said under Minnesota law, the government was allowed to keep all the property and all the proceeds from a tax sale, even the amount that was over and above the amount due and owing to the government. Well, Ms. Tyler sued, and I'm happy to report in a 9-0 decision written by Chief Justice John Roberts, the Supreme Court says, no, you can't do that. That is an unconstitutional taking of private property under the Bill of Rights, specifically under the Fifth Amendment's takings clause, where you're not allowed to take property from the government cannot take property from an individual without just compensation, and that obviously did not happen here. The government just basically took the $25,000 and kept it. So the Supreme Court says, nope, can't do this under the text and the history of the Fifth Amendment's takings clause. It is a no-no, and they said it was not allowed. Specifically, what the Supreme Court said in concluding it says, quote, the taxpayer must render unto Caesar what is Caesar's, but no more. That was the concluding sentence, effectively, of Justice John Roberts in the 9-0 decision by the Supreme Court, and I think that's the good outcome. But the methodology and the interpretive approach that the Supreme Court applied here is extremely helpful for Second Amendment litigators out there for following what the Supreme Court has instructed for many reasons. Again, first of all, is they applied history and not interest balancing, which again is consistent with the Supreme Court's understanding and interpretation of the Second Amendment. So that's good news. The second thing is they also said that the state, and this is important for anybody in the assault weapon context, although keep in mind that in the assault weapon context, all you have to do is apply the in common use test. You don't need to do anything else, but let's set that issue aside for the purposes of this video. The Supreme Court specifically says that states cannot define problems in some way to avoid constitutional scrutiny. Specifically, what the state of Minnesota had done with their laws is to try to define private property in such a way that it would exclude that $25,000 excess amount that the government got from the tax sale, and by trying to define private property as excluding that amount, they said we didn't engage in a taking because we define private property not to include that, and because the Fifth Amendment talks about, private property or property, our, meaning Minnesota's interpretation of property, overrides the meaning and understand of property in the Fifth Amendment itself. And the Supreme Court says absolutely not. You states don't get to define stuff any way you want, and we're not bound by that. This is very good news for the Second Amendment context because, as you know, the anti-gunners are very good at labeling things and defining things. So next thing you know, an ordinary, semi-automatic hunting rifle becomes an assault weapon, or some magazine that holds more than 10 rounds as a standard capacity magazine becomes a large capacity magazine. So the anti-gunners are always very good at labeling stuff. As you understand, gun control is simply gun safety. So the Supreme Court says unequivocally that that is not going to fly, that they don't care what states define stuff is. They're going to actually get down to the bottom of it and look carefully at it. Specifically, what the Supreme Court said in Tyler about this was this, quote, the takings clause would be a dead letter if a state could simply exclude from its definition of property any interest that the state wished to take. You see what I just said there? Basically, the Supreme Court says we're not going to just take the word of these states because these states have every incentive to make stuff up to avoid constitutional scrutiny, and they're not going to do it. So that's very good for the Second Amendment community, but it gets a lot better. Now, the next way that the Tyler case is really helpful for the Second Amendment is, remember, there's this ongoing debate that the anti-gunners are trying to get inferior courts or lower courts to look to the late 19th century to find examples of gun control laws to say that, look, in the late 19th century, after the Civil War, after the adoption of the 14th Amendment in 1868, there's all these gun control laws, many of which, by the way, were racist against the freed slaves, but set that issue aside for now. Basically, what the anti-gunners are trying to do is to get people, and specifically courts, to look to the late 19th century to narrow the scope of the understanding of the Second Amendment as it was understood when it was adopted in 1791. Now, this is very important. Keep in mind that the Bill of Rights was all adopted together in 1791. That includes the Second Amendment's right to keep and bear arms and the Fifth Amendment's takings clause. Therefore, if you look at the Tyler case and the way the Supreme Court interprets the Fifth Amendment's takings clause, we can learn a lot about how the Supreme Court looks to interpret the rest of the Bill of Rights, including but not limited to the Second Amendment's right to keep and bear arms, because they were all adopted as part of the same document, the Bill of Rights, and at the same time, 1791. So let's see in the Tyler case how the Supreme Court went about interpreting the Fifth Amendment and see if that teaches us how to interpret the Second Amendment. And the answer is a lot of good lessons here, totally consistent with Heller and totally consistent with Bruen. So it's all great news. In fact, it's even better than great in certain respects, and you'll see why in just one second. Specifically, the Supreme Court in Tyler, dealing with the Fifth Amendment's takings clause, laser focused on the time of the founding. And they specifically go back and say, are there any historical examples of where states or anyone could basically try to take money over and above what was owed for, let's say, taxes? And essentially, the Supreme Court says, no, that's not really the case, with three exceptions we're going to get to in one second. But the way the Supreme Court does it, again, they skip interest balancing. They go right back to the history of the Fifth Amendment and the history of private property. They start all the way back in 1215 with the Magna Carta, where they say even at the time of the Magna Carta, a sheriff or a bailiff who was deployed to collect debts, could not take more than what was owed to the government, going all the way back to the Magna Carta in 1215. Then it goes on to talk about subsequent English law, and they even quote one of our favorites, William Blackstone, the English lawyer who wrote the English commentaries on the laws of England. And he, at the time, it's just interesting, in 1771, William Blackstone wrote at the time of our founding on this issue involving the private property rights. He wrote, quote, "If a tax collector seized a taxpayer's property, he was bound by an implied contract in law to restore the property on payment of the debt, duty, and expenses before the time of sale, or when sold, to render back the overplus." You see, the excess had to go back. The Supreme Court, again, relies on William Blackstone. Blackstone is overall very good for us in the context of the Second Amendment. Here we have the Supreme Court in the Fifth Amendment context dealing with the Bill of Rights, also relying on William Blackstone. Again, further positive evidence in our favor when it comes to the Second Amendment rights. The Supreme Court's using Blackstone both in the Fifth Amendment and the Second Amendment. Good news. Then it goes on, the Supreme Court in Tyler says that these basic laws about how you apply the definition of private property, quote unquote, the principle made its way across the Atlantic. Specifically, the Supreme Court says that in English history came across to the United States. And then again, and this is very important, if you're a Second Amendment litigator, read this carefully. I repeat, if you're a Second Amendment litigator involved in these Second Amendment cases, read page 7 of Tyler very carefully, specifically footnote number 1, because they're talking about the following. This is what the Supreme Court writes. They're using these founding era laws. And notice the time period, the founding era, not late 19th century, but the founding era. Specifically, it writes, 10 states adopted similar statutes shortly after the founding. You see what I said there? Shortly after the founding. Again, it goes back to the point that the critical time period for understanding the Bill of Rights, you need to look at history, whether it be the Second Amendment or the Fifth Amendment, is at the time of the founding or immediately thereafter. Page 7 of the Tyler case proves this exact point. And if you look at the dates in footnote number 1, you're looking at laws that really run from 1787 to 1801. Again, exactly at the time of the founding, or a few years thereafter, but you're never getting to the late 19th century. Now, the next way that Tyler is extremely helpful for the Second Amendment community, especially on the 1791 issue, is because it reminds everyone that the role of the 14th Amendment, 1868, is simply, it can be relevant. Again, this is critically important to understand this. It can be relevant. Laws at the time of the adoption of the 14th Amendment in 1868 have the possibility, when you interpret the Bill of Rights, of being relevant. It's possible for it to be relevant, but in a particular way. Specifically, it is a one-way ratchet in favor of freedom. What do I mean by that? You see, any authority or history at the time of 1868, it can be used as a confirmatory analytic. I repeat, a confirmatory analytic that basically says that if you look to the understanding of the Americans when they adopted the 14th Amendment with some aspect of the Bill of Rights, whether it be the Fifth Amendment's takings clause or the Second Amendment right to keep and bear arms, you can use the 1868 understanding of those laws, provided that they are consistent with or confirm or affirm the understanding of the Second Amendment or the Fifth Amendment in 1791. And this is exactly what the Supreme Court in Tyler just reaffirmed. The Mark Smith explanation, which I made repeatedly, not just on this channel, but in law review articles, describing that the Supreme Court always looks to 1791 to understand the Bill of Rights, but they will look to the late 19th century, but only to confirm the understanding of 1791. They cannot, and they will not use contradictory historical evidence from the late 19th century to undermine or cut or shrink the scope of the Second Amendment or the Fifth Amendment right here in 1791. It can only go one way, to expand the right or confirm the right. It cannot shrink the right, because that would be contradictory with the 1791 understanding. That is not allowed in Supreme Court jurisprudence, and the Supreme Court just reaffirmed this on page 8 of Tyler. Specifically, what the Supreme Court says is this, quote, "The consensus that the government could not take more property than it was owed held true through the passage of the 14th Amendment." Do you see what I just said? The Supreme Court is saying that the 1791 understanding that government could not take property to pay a tax bill and keep the surplus was a consensus that a government could not take more property than it was owed, held true through the passage of the 14th Amendment. Again, they are using the 14th Amendment and the laws in the history at the time of the 14th Amendment in 1868 to confirm reaffirm the 1791 understanding of the Second Amendment. That's what they're saying here. That our understanding of the 1790, they go through in this case of Tyler, they talk all about the founding era history, they talk about the English history, they reach the conclusion that government cannot take more property than what is necessary to pay off that tax bill under American law at the time of the founding. Then they go on and say, and at the time of the 14th Amendment, that view was still the view which is serving as a confirmatory analytic of the 1791 understanding. Page 8 of Tyler, again, reaffirms the Mark Smith view. It's right here, not Mark Smith, not the 4 boxes down, but the U.S. Supreme Court itself. Page 8 of Tyler reaffirms the view. Again, 1868 can only confirm, it cannot contradict the 1791 understanding of the Bill of Rights, whether it be the Second Amendment or the Fifth Amendment or any other aspect of the Bill of Rights. Now, the last thing, and this is very important for those of you out there in California and any other states dealing with the handgun roster issue, this is hugely important. I'm going to get super geeky on this, but you're going to be really happy when I show you the good news. Specifically, in the context of these handgun roster cases, these all should be, before I get to the Tyler case, these should be very easy, right? At the end of the day, these handgun roster cases, these handgun roster laws are gun ban cases. They are banning commonly owned guns by Americans outside of these jurisdictions. The in common use for lawful purpose test should apply from Heller. It is a slam dunk. These handgun rosters, in my view, are clearly violative of Heller and the in common use test. It's a no-brainer. It's simple, slam dunk, game over real fast. Nevertheless, we obviously, as Second Amendment advocates, you obviously, especially if you're lawyers, argue in the alternative, assuming arguendo, and that is the case here. So the California governments and those governments that support gun control, they're using a kind of a new argument dealing with what are known, and I'll do a whole video on this, but they're called proving statutes. P-R-O-V-I-N-G, proving statutes. What are proving statutes or proving laws? Okay. These were laws that came from Europe. Proving statutes were really part of guilds, and specifically the ideas were these are effectively founding era or before founding era type consumer product safety laws, meaning that the proving laws required people to prove that the barrels on the guns would not blow up and hurt the user. So sometimes you had to prove that these barrels, these guns, would again not blow up and hurt the user. In Europe, they were called proving laws. They brought the United States, but here's the kicker. And this is why the Tyler case is extremely good news for those of you out in California and cases like the Bolin versus Bonta case and those other cases out there involving the handgun roster. You see, in these proving laws dealing with proving that guns don't blow up, there's only 2 that are known to exist at the time of the founding. There was a proving law in Massachusetts, and there was a second proving law in Maine, although Maine got carved off from Massachusetts. So there's only 2 proving laws in the founding era in the United States, one in Massachusetts and one in Maine. Only 2. Why is this so important? It's important for several reasons. Because if you then look to the Tyler case, and this is where the dots get connected up. If you look at the Tyler versus Hennepin County case dealing with the Fifth Amendment, the Supreme Court there also looked at founding era laws that allowed government to take the full amount of the property, even the amount of property in excess of what was owed on tax bills. And this is what the Supreme Court said. The Supreme Court rejected, I repeat, in Tyler, the Supreme Court rejected the fact that there were 3 laws on the books at the time of the founding that allowed government to take the full amount of the property in a tax sale, even the amount over and above what was due and owing on the taxes. 3 laws, and the Supreme Court says that was not enough. Did you hear what I just said? That was not enough. 3 laws at the time of the founding that allowed this were not enough in Tyler, which means, of course, by the principles of Aish, Forsyth, Ori, if it's true for the lesser, it's true for the greater. If 3 laws at the time of the founding were not enough to cut back on the Fifth Amendment's right to private property, the 2 laws in the 2 proving laws in the context of handgun roster cases obviously is a smaller number than the 3 in Tyler. So the 2 proving laws being discussed, for example, in Bolin versus Bonta, is obviously not going to be sufficient to do anything given the fact that the U.S. Supreme Court, rejected 3 laws as not being sufficient. So if 3 laws are not sufficient in Tyler, 2 laws will not be sufficient in Bolin to justify restricting our Bill of Rights, including the Second Amendment, or in the context of Tyler, the Fifth Amendment. Beyond that, the other very helpful fact in Tyler that's very good for the Second Amendment community specifically is that, as you remember, just to jog your memory really quick, Outside of the context of gun ban cases where you apply the in common use test, and all other aspects of gun regulations in modern day America, you apply the text first, and then you look to see if the government can come up with any historical analogs. Again, once the text is implicated by the Second Amendment by virtue of a modern day gun control law, the burden shifts to the government to show that there are historical analog laws at the time of the founding that justifies the law, that justifies the modern day gun law. The example I always give is at the time of the founding, the right to keep and bear arms was there, but there was also very clear laws at the time of the founding through today that say you cannot misuse a firearm by committing murder, rape, or robbery. Those are the kind of historical legal tradition of restricting the use of a firearm, or in that case, the misuse of a firearm that has been on the books since before the founding through today. So therefore, if you were indicted for murder with a firearm, you cannot assert a Second Amendment right that you could commit murder, because at the time of the founding through today, you could never again use a firearm to commit murder. That's the sort of thing that the government bears the burden to come forth and prove. And if they can't come forth with that kind of long-standing historical tradition of firearms regulation, they lose. When in doubt, throw it out. That's Mark Smith's rule. When in doubt, throw the law out. It goes out the door because the government cannot meet its burden. So here is, I think, the Supreme Court in Tyler has just strengthened the case for the Second Amendment involving this Fifth Amendment case, beyond the fact that the Supreme Court in Tyler said that 3 examples of some sort of restriction was not enough to restrict our Fifth Amendment rights. So too would the 2 examples for the proving laws not be sufficient to restrict our Second Amendment rights, assuming historical analogs even apply to a gun ban case, which they don't. Nevertheless, let's carry on. There's 2 other critical things that Second Amendment litigators need to know about the Tyler case. It's very helpful. The first is there were 3 laws that the government defendant had come up with in Tyler to try to justify their unconstitutional taking of property. One of those laws was one in Louisiana, one from Maine, and one from Mississippi. In addition to the fact that the 3 were not sufficient, they also point out that 2 of these laws were temporary. I repeat, they were temporary, and therefore another added reason why they are not able to cut back on the understanding of our Fifth Amendment rights to property. And the other one, and this is equally important, was never enforced. At least the government defendant was not able to prove that it was ever enforced. Specifically what the Supreme Court said when they dealt with the Louisiana, the Maine, and the Mississippi laws associated with a government could take all the property, even if they only owed $1, you could take $5 worth of property and keep all $5. There's only 3 examples of this at the time of the founding, all of which really the Supreme Court found unpersuasive for various reasons. Specifically, what the Supreme Court wrote was the government, i.e. the county, identifies just 3 states that deemed delinquent property entirely forfeited for failure to pay taxes. One was in Maine, one was in Louisiana, one was in Mississippi. The Supreme Court went on, and this is critical language for those of you fighting about historical analogs in the context of the Second Amendment. The Supreme Court wrote in Tyler, two of these laws did not last. See what I'm saying? Temporary laws, that does not make a basis for you to be able to take away Second Amendment rights or Fifth Amendment rights under the Bill of Rights. It goes on to write, Maine amended its law a decade later to permit the former owner to recover the surplus. And then it goes on to say, in Mississippi's highest court promptly struck down its law for violating the Due Process and Takings Clause of the Mississippi Constitution. So the Maine and the Mississippi laws were temporary. The Supreme Court said those don't count to restrict Fifth Amendment rights. Thus, temporary laws that arguably could restrict Second Amendment rights at the time of the founding won't count either. Last but not least, and this is very important for you Second Amendment advocates out there, the Supreme Court in Tyler said the following about Louisiana's law. It says, quote, Louisiana's statute remained on the books, but the county cites no case showing that the statute was actually enforced against a taxpayer to take his entire property. Did you hear what I just said? This is extremely important for you Second Amendment advocates out there. The Supreme Court in Tyler specifically was looking not just for a sufficient quantum of laws at the time of the founding, not just to make sure that those laws were permanent and long-standing, i.e. not temporary. They also wanted evidence, again, to make sure that those laws that were on the books at the time of the founding were actually enforced, were actually used. The Supreme Court wrote, quote, the county cites no case showing that the statute was actually enforced. See what I just said there? So in addition, even if the anti-gunners can come up with gun control laws on the books at the time of the founding, they also bear the burden, as I see it, based on this Tyler language, to show that those laws were not just on the books, but they were actually enforced against Americans. And if they cannot do that, they lose. Again, more arrows in the quiver of Second Amendment advocates if you read the Tyler versus Hennepin County carefully. If you read this case carefully, I'll put a link to it down below. A lot of good stuff in there. But again, you have to be able to connect the dots. Luckily, we know a handsome YouTuber that's able to do that for all of you out there. So take a look at that case, check it out, and Godspeed. Okay, folks, if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon at the Four Boxes Diner.
Orders up. Table 2A.